SJC-13564, Tenants Development Corporation et al., the AMTAX Holdings 227 LLC et al.
Okay, Attorney Davenport, whenever you're ready.
Morning, Your Honors. Maybe afternoon, I don't know.
Not yet.
It's an honor and a privilege to be here. I have the distinct privilege of representing Tenants Development Corporation, which is a historic nonprofit here in Boston. It's all laid out in the pleadings, but it's important to note, just for context, as we begin to dive into the nature of the dispute, that they are a nonprofit who participated in the low-income housing tax credit program, of which this court is familiar because of the decision from 2018 in the case of homeowners rehab. Normally, I would spend a lot of time in cases like this talking about the low-income housing tax credit program because it helps to inform the context and the objectives of the contracting parties, which are important when we're looking at intent and what were they trying to accomplish with this Section 42 ROFR. But rather than spending a whole lot of time in context, unless the court had questions there, I'd like to turn to the issue that you solicited amicus briefs on relative to the purchase price that's established by the Section 42 I-7 ROFR that is contractually agreed to in the contracts that TDC entered into with the express purpose of being able to reacquire its property that was deeded to it in 1973 by the historic it escapes me. It'll come to me in a moment. The Redevelopment Authority. Thank you, Your Honor. It was deeded to the nonprofits in 1973, and then fast forward about 20 years later, and they put the property into the program in express agreement for the right to reacquire it for the principal amount of debt secured by the property and the taxes attributable to such sale. And as this court knows, the crux of the dispute that we are appealing relates to that limited phrase, taxes attributable to the sale. I think it's important to note that we have bedrock contract interpretation principles that help us inform the decision that we hope you will make, which is to reverse the Superior Court for the decision that it made that this nonprofit should have to pay potential assumed exit taxes for an institutional investor who has received more benefits from their investment than they contributed and ever anticipated. That is what is.
Can I ask you to address the Section 2.5 of the limited partner agreement, which, and I'll just read it to you. It says, the partnership shall be dissolved upon the happening of the sale of all or substantially all of the property. Why is that dissolution and the taxes attributable to it not part of the taxes attributable to the sale of all or substantially all of the property?
Thank you, Your Honor. Because that dissolution will not occur concurrent with or coincident to the sale of the property. We know that from.
But the language that you just pointed us to was taxes attributable to the sale. It doesn't say taxes incurred coincident to the sale. It says attributable to the sale. And one of the things that follow from the sale, according to the limited partner agreement, is that the partnership is dissolved. It says shall be dissolved.
The partnership shall be dissolved through an orderly liquidation process that follows the terms and conditions of the liquidation and dissolution provisions in the partnership agreement that follow the distribution of sale proceeds from a sale under 6.2B.
But it's weird because it doesn't say followed, it says prior.
Which section, Your Honor?
I'm looking at the same section as Justice Wentland. It says shall be dissolved prior to such date upon the happening of any of the following events. So it's either before or upon. Those are the two, but nothing says following.
So what happens, Your Honor, is the partnership has more assets than just the property. And when the property is sold, Section 6.2B instructs what's supposed to happen with the sale of the proceeds. And then upon the occurrence of that sale and the distribution of those proceeds, the partnership has had an event of liquidation, an event of dissolution, something that triggers the need to subsequently wind down the partnership and its remaining assets. And we know that from case law that has been uniformly determined in different states, not the Commonwealth, but in Florida and New York and in elsewhere, where they have said that the sale is an event that will trigger the subsequent liquidation. We know that from Hopkins Court, we know that from St. Mary's, we know that from the CED cases down in Florida, and we know that from a decision that was rendered by the Northern District of Illinois just recently that we provided through supplemental authority. So there's this, call it a two-step process, if you will. Most certainly, what is going to happen upon the sale is a distribution of the proceeds from the sale. And then the partnership is going to sit back and say, what does my partnership agreement tell me I need to do? I now need to dissolve and liquidate. Okay, what are my remaining assets? But as the partnership is doing that, it's then liquidating those remaining assets, potentially distributing that cash. But the partnership does not dissolve the day of the sale and the distribution. It just can't. The partnership's going to have trailing obligations. It's going to have trailing liabilities. It's going to have to allocate the gain from the sale or the loss from the sale to the partners, right? So you distribute the proceeds, and there was a question I think asked in an earlier argument here today.
The dissolution is a necessary consequence of the sale.
That is correct.
Then why isn't that enough to mean that it's associated with it?
I'll give you an example. So right now, on the books and records of the partnership, there's a negative capital account reflected for the limited partners. That allegedly is going to lead to them having exit taxes when the partnership is dissolved. That negative capital account has nothing to do with the sale of the property. So whatever taxes they may have today, if they were to exit today and before the sale,
It's caused by the dissolution, right?
that's when they have to pay. But what causes their exit tax liability if this pass-through entity that has no tax liability has to ever pay taxes is when it's due. Like when you look at the capital gain, you look at the different assets, and this court has said—
When will it become due?
It will become due when they exit the partnership.
Which is upon dissolution?
It's going to happen upon dissolution
And
following
the
the sale.
dissolution is a necessary consequence of the sale of the property.
Ultimately, yes. So that's the issue that we struggle with, is where does the causation end and begin? Because attributable to, when we look at the dictionary definition of it, is caused by an event. What is the event that causes this to happen? Their current exit tax balance, capital account balance, has nothing to do with the sale of the property. It exists because they've received more benefits. It exists because of the operations of the property. It has produced losses. Those losses were allocated to them. Maybe they took them. We don't know. We don't know if they carried them forward.
Is the fact that they got more a timing issue? I take it one of your arguments is you could sell without their permission at any time, right?
We can't sell without their permission. In order to enter into a binding agreement to sell, we have to have consent of the limited partner. We can propose for purposes of triggering the ROFR to sell, right? We'll get into the consent issue later, or I can do it now if you want, but to your question, we can't.
I'm trying to understand, because in order to get this low-income housing built, we've created these tax benefits for basically your opponents here. And you're saying, well, they already got what they were entitled to, and now they're looking for more. But I'm just trying to understand the timing, because I take it sometimes they wouldn't have. And the fact that they did good by doing good, we want to encourage, right? We want them to.
Sorry.
That's the whole purpose of the statute, is people with the money are investing in low-income housing and they wouldn't otherwise do it. And the benefit for them is the tax benefit. And you're sort of saying, well, it's limited though. But I'm trying to understand the principles behind that. And
Sure.
I don't get it as well as my colleagues do at this point at all.
I'm happy to unpack that as best I can, Your Honor, and please interrupt me along the way if you have a question about what I'm about to say. Their predecessors contributed the capital. The people that are controlling those limited partners contributed nothing. So the predecessors, the limited partners that are in the deal have
They've stepped in the shoes of those people, right?
That is
So that's
correct.
a distinction that doesn't matter.
Fair enough. Okay, so now relative to what the limited partners who contributed the capital, they were investing in housing credits, which are a dollar-for-dollar reduction on the income tax obligations that they will have on an annual basis, and they were investing in the allocation of losses, which results from depreciation and other things that stem from operations. Those loss allocations are made on an annual basis through the tax returns and the K-1s. Those loss allocations exceeded the anticipated value of their investment when coupled with the anticipated housing credit benefits. So they received more tax benefit than they paid into the partnership to receive. No one begrudges them for that, and that's not what we're trying to suggest at all. But we are trying to suggest is, absent a contractual basis that obligates TDC to pay their exit tax liabilities at some point in the future when they leave and the partnership is unwound, that's on them. We don't believe congressional intent, which will help form the decision that this court is going to make evaluating the contractual provisions of the ROFR. We don't believe congressional intent was ever to shoulder nonprofits with potential or actual tax liability from an institutional investor who received more than they should have received. Happy they got it. Happy my client has done a great job and delivered them additional losses. But they should shoulder their own tax liability unless they can prove that there's an agreement that expressly requires us to do it. The ROFR does not. The ROFR focuses in context on what are the partnership's obligations. There's two components of the price. What does the partnership need to do to deliver clean title to the buyer? In this instance, the buyer is TDC. In any other instance, it would be a third party. TDC needs to get clean title to the property. So the first thing that the ROFR looks at is the principal amount of debt. We have to give the partnership enough money to pay the bank, but in this instance, the contract allows, consistent with Section 42's purposes, for TDC to assume the debt if mass housing will allow them to assume the debt. Mass housing will allow them to assume the debt. So we don't actually have to have the cash on the day of the sale for that. But that's the partnership obligation. What else might the partnership have an obligation to do on the day of sale? It might have to pay a capital gain associated with, attributable to, on the date of sale. That's what we're talking about. The partnership's taxes attributable to the sale. It doesn't say the limited partners taxes. It doesn't say the general partners taxes. It says all state, federal, and local taxes attributable to the sale. We believe that in context, framed within the context of the program, TDC's mission, TDC's purpose, TDC's putting this property into the program in express exchange for this right, was never to pay anybody else's taxes. Just take care of the taxes that the partnership might have to pay when you're taking care of the liability, and that will inform your purchase price. That's why when Cohn-Resnick's accountant, Nick Ratty, here in Boston, sat down and did the calculation, when the ROFR became available, he looked at it and said, it's going to sell at a loss. It's like if you're selling a home that has a $100,000 mortgage and the market's gone terrible and you can only get a buyer for $80,000, you short sell it and you have a loss. Somebody is going to get the allocation of that loss. It's going to go somewhere. They get the losses. That may benefit them. If they take those losses, they will then have responsibilities associated with it. But critical here, they might not have ever taken the losses. Just because they were allocated to them doesn't mean that they claimed them and got a benefit. They could have suspended them, and if they have a tax liability that arises upon exit of the partnership 9 months from now when the thing is unwound and dissolved, they may have a tax liability and they can go into their loss bucket and say, hey, guess what? I suspended all those losses, now I don't have to pay any taxes. But we have to pay them cash anyway? That's their theory, right? And we say that's an absurd result. It's totally inconsistent with what Congress would have intended when it tried to incentivize nonprofits to be here. Very tellingly, they admitted at argument before the Superior Court when we went in on a motion for reconsideration, because there was this finding of, well, you're both reasonable. This is a colorable claim. You have a reasonable position. You have a reasonable position, but I think they have the better argument, so he went in their favor. I respectfully disagree with that honorable judge because I don't think their position is reasonable, because it's just conflicting with all sorts of things. But that was ambiguity, but that's not what he found. And so where we ended up with was, they are saying we have a hypothetical exit tax from an entity that's passed through for tax purposes and pays no taxes. They're simply trying to create a cash windfall. They want us to write them a check for $8.5 or $9 million that may never go towards paying anybody's taxes because they may never not even exist. So when we look at attributable to, we look at it within the lens of how is it framed up in the program, how is it framed up with the intention of the parties, because what we know from Bedrock, Massachusetts law, and as it's stated in the homeowners rehab case, we are intending to look at the context in which it was written with reference to the objectives sought to be accomplished. So when we look at the context within which the Section 42 ROFR was embedded in this contract, what was the objective it was intending to accomplish?
Can I interrupt you, sorry, for a second? So the limited partner agreement has something called an exit tax distribution. How, if at all, does that affect this case?
It's not applicable. It's the fourth item in the Section 6.2B waterfall.
Right, and how you allocate, certain funds from sales.
Yes, Your Honor. So in item 4 of that waterfall, it starts with, in the event of a sale to a qualified nonprofit entity pursuant to the LURA or tax credit reservation. The LURA is short for Land Use Restrictive Agreement. Neither one of those are applicable here, so there won't be an exit tax distribution, but it shows you if somebody wanted to memorialize an agreement to have the partnership pay an exit tax distribution, you could have done it. It's
Right,
not in
that's
the
why
ROFR.
I'm wondering why that argument was not marshaled, because it does, in my view, show that there was consideration of such a thing as an exit tax distribution and expressly named in the LPA. But then we have the other phrase used in the right of first refusal document, suggesting that they're different things.
Right, and so relative to what's in the section, in the right of first refusal, it tracks the language in Section 42I7.
Right, but it doesn't use the language of the LPA called exit tax distributions, which suggests maybe it's something else.
I think that's right, Your Honor. I also think that, one of the things that we attempted to provide the court with was examples of other rights of first refusal that are out there from other litigation, because trust me when I tell you, this is happening all over the country, where these folks are coming in and trying to strip the equity out of these communities after the end of the 15-year compliance period, and we're trying to put a stop to it. So we gave you examples of other contracts where people have expressly expanded the ROFR to include exit taxes, to include the investor exit taxes that will actually potentially be paid through the owners of the pass-through entity. So this ROFR is clean. It tracks exactly what's in the code, which is intended to be efficient and orderly, and in my estimation, limited only to what are going to be the partnership's capital gains associated with the sale. That's it.
What would be the consequences were we to conclude that the investor's consent was required, that the judge got that part of the decision wrong? How would that then play out? What would happen?
If I understand your question is, if you conclude that the judge got the consent issue wrong, what would happen?
Yeah.
It would eviscerate the ROFR. Just like if we end up with a purchase price that includes the potential exit
Well,
taxes.
I was thinking more mechanically. The whole case comes out the other way automatically. What happens?
If they have a consent right over TDC proposing to sell the property and issuing the disposition notice, they have a veto power. And it's just like what we saw in homeowners rehab. It will create a set of circumstances where this ROFR and potentially others, they can never be exercised because they will not consent to a sale at a below market purchase price. I may think they're unreasonable in a lot of ways, but most reasonable people wouldn't, right? If you can force a sale at market value of $50 or $60 million and then you can get all of that profit, you're not going to consent to a purchase, even if it included their exit taxes, right? Because they don't. right? They want to force the sale of the property so that they can take all the equity out of the community that has built up in it over the last 20-plus years while it's been in the program. That's the aim, that's the goal. So we know from homeowners rehab, there's one distinction that's without a difference in our case. In homeowners rehab, there was a carve-out that mentioned in the applicable provisions, the consent right, it referenced the option agreement. Here, our agreement doesn't reference the option agreement, but that's a distinction without a difference because all of the other analysis in homeowners rehab applies here. And to your question, what would happen is they would have a veto right. There would be never a circumstance under which they would consent because it's a below market purchase price. And it is the antithetical notion to congressional intent to establish perpetuity of affordable housing and income restricted rents for income qualifying residents if we make it cost prohibitive for the nonprofit to reacquire the property at the end of the 15-year compliance period when the credits are beyond risk of recapture.
So we would reverse the summary judgment and the litigation would continue.
I apologize, I couldn't hear you.
So we would reverse the summary judgment and the litigation would continue?
If you granted them a consent right?
No, if we said they did have a consent right, we're not, if they had the right to consent to the terms before the sale occurred.
We probably would not have, we would not have a ROFR that we can exercise, so we wouldn't have a claim
On this
anymore.
one, yep.
Yep.
I mean, maybe some future sale or something, but.
There would, in all likelihood, if you're asking what's going to happen in that event if we lose our ROFR?
No, I'm asking actually what the mechanical litigation consequences would be.
I see. I think in the mechanical litigation consequences, what would happen is there would be a determination that they have a consent right. We were not allowed to exercise the ROFR because we were not allowed to propose a sale. We were not allowed to issue a disposition notice, and then the properties would ultimately be sold, marketed to a third party on the market.
Who knows, yeah.
Because that's what got us here, because they told us, go sell the property, market it for sale. We have a right to force you to do it. And we did. We complied with our obligations under the agreement, and we got 8 offers, and then the general partner proposed on behalf of the partnership, pursuant to its exclusive authority, to sell to one of them. That triggered the disposition notice. That triggered the exercise of the ROFR. So they claimed, when the case started, we lied to them. 20 years ago, there was a fraud committed. The tenants didn't tell them about the ROFR, but we found out that the ROFR's been on title. We found out that their closing attorneys and the people that were representing them at the time knew about the ROFR, instructed it to be recorded against title, said where it should be filed. So that went away, but then it came back, apparently, in the arguments that we're seeing here on an appeal. I guess the piece related to all of this is this case was originally, at some point, went up to the First Circuit Court of Appeals, right? And the First Circuit looked at the ROFR, and they determined there was no federal question jurisdiction relative to the ROFR. And they confirmed that the ROFR is intended to be an efficient and orderly process for the nonprofit to acquire the property at the end of the compliance period. And it's subject to 3 requirements, and that's it. It can only be available at the end of the compliance period. It has to be to a qualifying nonprofit organization, both of which my client satisfy, and then it has to be the minimum purchase price. It can be more, but it can't be less. And so my respectful submission to this court is if the court were to affirm the Superior Court on the interpretation taxes attributable to a sale should include exit taxes, you are expanding the contractual language of the minimum purchase price, and that would result in TDC having to shoulder the burden of taxes that we say in no certain circumstances are due to property operations, excess benefits, their potential use, whether they claimed them or not, from their exit from the partnership. And last thing on the gains and the losses. As the partnership is going through the liquidation and dissolution process, there's going to be other distributions when you're liquidating remaining assets. They're going to get more loss allocations. They might get gain allocations. That's why we don't know at the time of the sale what their actual exit tax might be, because it's not calculatable on the day of the sale under the ROFR, which is why the district court put us in this conundrum, because if they have a consent right and we can't determine the purchase price on the day of the sale, we'll never get there. So we would respectfully request that the court reverse on the issue of the exit taxes and what taxes attributable to a sale are, and affirm on the consent issues, and let us move on so that we can potentially get back into the district court, get the case resolved, because this is having real economic impact on the ground and has delayed for 4.5 years my client's ability to get a community center built through the equity that it has established in this property and should stay with this community. Thank you.
Okay, thank you. Attorney Dolan.
May it please the court, my name is Louis Dolan. I represent the appellees and cross appellants in this matter. The appellees, as you know, are the limited partners in the limited partnership that owns this property in the south end of Boston. They are also investors in some 1,800 affordable housing projects throughout the Commonwealth and throughout the United States.
So can I ask you to start with the definition of exit tax distributions that were expressly set forth in the LPA, and then the less than clear language of the ROFR, which talks about attributable to the sale?
The point about the taxes being attributable to the sale, Section 2.5 of the Limited Partnership Agreement. Please keep in mind that this partnership is what is known as a single-purpose entity. That means it has one asset, not several assets. Its single purpose is to own and operate this property. It may have some cash on hand. It may have some reserves that are typically transferred with the property. It may have some office furniture, things like that, but its substantial asset is this property. And therefore, as a result, and you're asking exactly the right question, Section 2.5 of the Limited Partnership Agreement says, this partnership agreement shall dissolve, this partnership shall dissolve upon the happening of the sale of the property. And that makes good business sense, because the sole reason that the partnership exists in the first place is for operations of the property. The reason that these taxes arise because of and are directly attributable to the sale of the property, as the Superior Court found, relying on our expert report, and also relying on numerous points in the record where the partnership's own accountants at Cohn-Resnick
All right,
did
so what,
precisely
so
the
the
same.
LPL actually has a defined term. It's called exit tax distribution.
Yes.
What is that?
That is the distribution that is to be made upon the dissolution of the partnership, the exit taxes. That
Right, and my point is that the ROFR, instead of saying exit tax distribution as a defined term, talks about all federal and state taxes attributable to the sale.
Correct.
So given that there is a defined term, exit tax distribution, in the overarching agreement, isn't it odd that the ROFR does not use that same defined term?
The ROFR
Especially
didn't-
when the ROFR says that it's incorporating the defined terms from the partnership agreement.
The right of first refusal has to comply with minimum requirements under 42 I-7B2 of the Internal Revenue Code. That language, as the Superior Court found, indicates all taxes attributable to the sale, which include and incorporate exit taxes and taxes on gain from the sale. And what has happened here in this case, we didn't reap a windfall in terms of the losses that were allocated to us over the life of this partnership. We bargained for the losses that we received.
So
That's-
you're saying exit tax distributions is a subset of all the potential taxes attributable to the sale.
Yes.
Okay. and so
Exit taxes
that would
are-
explain why you wouldn't use the same defined term.
All
Because
means all.
is, there's more than just the exit tax distributions. There's this potential capital gain you're talking about.
There could be capital gains. There are gains on the sale, which is what would happen in this instance once the debt is assumed. There is gain that is recognized on that sale. And certainly the Department of Treasury, which has revisited this section of the code many, many times over the years since 1986, 1987, when it was adopted and has not changed it, knows how to change and make an exception in the portion of the tax code that says all taxes.
Can I ask you to address your opposing counsel's argument regarding, I think it was that you can't tell what the actual taxes that the limited partnerships will incur as a result of the dissolution of the partnership until a later point in time, so that the is it TDC? The TDCs of the world can't set the purchase price, because that, if exit taxes is included in that purchase price, that's something that's in the future will be determined.
That's fundamentally incorrect, and it happens every day in this business that taxes are calculated, including exit taxes that would be due on sale. And what happens as a practical matter, again, to use the analogy, it's similar to selling your home. When you get a settlement sheet in from a title company, and on that settlement sheet there are buyer's columns and seller's columns, and the taxes are calculated on those sheets, and the taxes are paid by the buyer, right, of this property. Because it's called the minimum purchase price, right, that is the price that the buyer must pay to the partnership. And that is calculable with respect to exit taxes, because what we do, the exit tax calculation, is a very simple formula. Everybody in this courtroom knows what it is, because their own account.
Some of us might not.
I wouldn't go that far.
I apologize.
There's a few people in the courtroom who
Everybody on
know.
this side knows what it is, because the record is replete with citations where their accountants calculated the exit tax using precisely the same methodology that we did and that our expert did. And it is taking the negative capital account, right, which is reported in the federal tax return from the prior year, calculating the effective tax rate that this partner has, and coming up with those numbers. So it is not a complex calculation. It is a calculation that is routinely done, and routinely done as a part of closings on these projects.
What is the code provision that applies to when the exit taxes are liability is accrued, created, whatever the right verb is for that?
Your Honor, to my knowledge, there is no specific Internal Revenue Code provision that addresses that, other than 42 I-7B2, which speaks to all taxes attributable to the sale, and that says all federal, state, and local taxes.
That tracks the language in the right of first refusal.
I would phrase that slightly differently, Your Honor. The right of first refusal tracks that language.
Okay,
Yes,
fair enough. And
because
that,
the right of first refusal came subsequent to.
so does it refer to attributable to the sale, or does it say attributable to the dissolution, or does it say something else? When does it, when is there anything in the code that would tell us that from the federal government standpoint, the exit taxes are triggered by dissolution, sale, or something else?
I don't believe that there's anything in the code specifically on that, but what the Superior Court judge found was it relied on this court's prior precedential opinion in homeowners rehab from 2019, where the court went through and demonstrated a very fine knowledge of how this program works, and included within that opinion the report from the United States Department of Housing and Urban Development, which works hand in hand with the
Okay,
Department
but
of
I don't think we were offering a tax opinion for these investors as to when they need to calculate or report or pay, account for, whatever, their exit taxes. Did we?
In that case, there is certainly, and it's not the holding of that decision, but there is certainly reliance on the HUD report, including in footnote 5, citing 42 I-7B2, which specifically says exit taxes are part of the minimum purchase price because they are part of all taxes attributable to the sale. And, Your Honor, this court cited that report 7 separate times in that opinion. It relied on it. It found that report authoritative. The Superior Court found that thinking and that decision, again, it wasn't a direct holding, but authoritative in the absence of other direct authority on point throughout the country.
Can I get you?
So we take that, right? We take industry knowledge in this situation, which is now coming up on nearly 40 years for the most important housing tax credit program, housing program in the United States and in this Commonwealth.
Could you take a shot at, my colleagues have focused on the precise language. Can you take a step back and explain to me sort of the policy reason why? Because your opposing counsel stands up and says, look, you're making it much more expensive for these type of development corporation, tenant development corporations to take over and continue this program. Tell me why you getting cashed out is not only consistent with the precise statutory language, but with the statutory intent here. Because it's making this more expensive. I just want to understand why. Because they're saying you're getting a windfall, and I'm trying to understand whether this is what Congress intended or not.
There is absolutely no windfall in this. So if you go back to the original intent in the legislature and Senator Mitchell, who was one of the sponsors of this bill back in the 1980s, what he specifically said remains true today. And, Your Honor, I think you picked up on this point earlier in your conversation with opposing counsel. What Senator Mitchell said is this is an uneconomic activity in general, investing in affordable housing, and we need to make it attractive for investors to invest and put private capital to work. And that's what we have done here. Now, if you want...
So let's take the next step. They're saying you guys, it was successful. You've cashed out. You've been able to depreciate or write off a lot of taxes in the past. Now, why at this stage here at the sale, where you've already gotten more than your investment out, did Congress intend for you to continue to benefit from this, even though it's going to raise the price of the purchase for people like your opponents here, who are going to continue the activity
Yes, let me answer that.
Congress wanted to maintain?
Let me answer that very directly. Because the tax liability that we're talking about currently, the exit tax liability is approximately $8.5 million. That wipes out the lion's share of our benefits received over 15 years. And so if you simply take away the vast majority of those benefits that we have patiently been collecting and gathering for 15, it's going on probably closer to 20 years at this point, and say you actually don't get those benefits, what private investor is going to say that makes good sense for me as an investment, unless they're simply doing it out of the goodness of their heart? There are some that will do that, but to meet the mission and the statutory purpose and intent of attracting private capital, you simply can't do that. So let me, if I also could flip the script here a
How do
little
we
bit.
know that? Is that in the record somehow?
I'm sorry, which?
This policy argument that you're making, that if you don't have the exit tax liability be part of the minimum purchase price, that the investors that Congress was trying to woo would, not have the benefit of the tax credits that they were initially given, that it would essentially wipe them out, is what you're arguing.
Let me be very clear. It would not completely wipe out all of the benefits, but it would take away the lion's share of those.
But regardless of what percentage of the benefits, where is that in the record?
In the policy argument?
Yeah.
The policy argument, I believe, is in part in response to the amicus briefs, who try to raise a number of policy arguments which are simply incorrect.
Your point is it's Mitchell. It's that we wouldn't, people like your clients are not in it to, like his clients, to promote low-income housing. They're in it for the money, and they're not going to put their money in unless they're going to get their money out of it, right? That it comes down to Mitchell's overall conception of what the statute was about.
Well, to say that we're in it for the money is a pretty rough cut, I would say, Your Honor. I mean, we do have a mission of supporting affordable housing, and there are any number of these projects, these properties throughout the country that we have actually put in more money than we are required to because the properties need it. And so we're not just in it for the money, but we are in it and entitled to and have bargained from day one to receive an economic benefit. And so if I could, for just a minute, let me flip the script here and talk a little bit about this windfall, right? So what would happen in the circumstance of this $8.5 million? At this particular time, this property is worth on the order of 50 to 60 million, based on appraised values given by reputable local brokers as of a couple of years ago. Whether that number is exactly current, I don't know, but let's just say it's in that ballpark. What the economics of the transaction that the TDC parties are proposing would be that their affiliate nonprofit entity assumes the debt of approximately, if my numbers are correct, 17 million, pay nothing else, and for that get a property that's worth something on the order of 55. So where is the windfall in that whole equation? Is it wiping out the tax benefits?
But it just depends upon the situation, right? I mean, the numbers could be different in a different...
Of course, they're very different in different projects. And the concept here that we have reaped a windfall, right, and they're grateful that we've had all of these additional losses. The additional losses that we've taken have happened because of poor property operations, right? This is not something that we are sitting back saying, oh, this is great, we get more losses. We would far prefer to see
What was the value of the tax credits that you got?
it's on the order of 10 million.
Okay.
And what percentage, did your predecessors pay the full amount? I mean, there's a 99% thing somewhere. Were your predecessors the source of all the money for the building of the building?
They put in all but $1,000 of the initial capital, which was on the order of, initially it was $10.7 million. That number increased slightly over time to about 11 million. That is, and that came in through the AMTAX entity that is still the partner in the partnership for who we acquired their interests. So that is correct. We created a secondary market for their interests out of a bankruptcy proceeding, if I recall correctly. And then let me, if I could just take one moment more, I know I'm over time, but one moment more to address just in general some of the cases that opposing counsel has cited. Those cases involve the determination of fair market value of of property so that interests within the partnership can be transferred. They do not deal with the situation where there is a direct sale of the property, which is the sine qua non for this partnership, and without which this partnership no longer exists. So those cases, they're out there, they certainly are, but they're very different. And with that, unless there are other questions, I'll thank you.